Salam sejahtera. I'm going to do a case review of the case JP Logistics Syndrome Berhad against Holsten Marketing Syndrome Berhad 2020. This case involved a dispute between plaintiff and the defendant regarding the payment of storage charges for a container stored in the plaintiff warehouse. The plaintiff claimed payment for storing the container from 29 January 2014 to 17 November 2016. However, the defendant argued that they had only signed a quotation that had expired on 31st March 2014 and asserted that the Malaysian Quarantine and Inspection Service was responsible for the container's detention. As a result, the defendant denied any liability for the storage charges. The Session Court dismissed the plaintiff's claim, finding that the evidence presented was insufficient. The plaintiff then appealed to the High Court, but the appeal was dismissed. The main issue in this case is whether email correspondence and letters between the plaintiff and the defendant could be admitted as evidence. The plaintiff attempted to present these communications to show that the defendant had agreed to pay the storage charges. However, the court found that these documents were part of settlement negotiations between the parties and needed to be assessed under Section 23. Section 23 states that in civil cases, admissions are not relevant if they are made on the express condition that they cannot be used as evidence, or in circumstances where the court can infer that both parties agreed that the admission should not be used as evidence. The plaintiff argued that the emails and letters between them and the defendant demonstrated the defendant's admission of liability for the storage charges. The plaintiff also claimed that even if the communications were part of settlement discussion, they still contained admissions that should be admissible as evidence. Meanwhile, the defendant argued that all communications and questions were made in attempt to settle the dispute out of court and therefore should be inadmissible as evidence. The defendant cited legal principles stating that settlement communications are privileged and protected under the without prejudice rule. For the decision, the High Court agreed with the defendant's arguments and ruled that the communications were part of settlement negotiations and therefore protected under Section 23 of the Evidence Act. As a result, the plaintiff appeal was dismissed and the Sessions Court decision to exclude the evidence was upheld. For ratio decedendar, settlement discussions are not evidence under Section 23 of the Evidence Act. Statements made during settlement talks cannot be used in court if they were meant to be confidential, even if not labeled without prejudice. The court ruled that the emails and letters in this case were part of settlement discussions and were therefore inadmissible. Second, negotiation does not mean admitting fault. Talking about a settlement does not mean a party is accepting liability. The plaintiff tried to use the defendant's statements as a proof of liability, but the court found that they were just part of negotiation efforts and not an actual admission of fault. In conclusion, this case shows how Section 23 of the Evidence Act 1950 protects settlement talks from being used in court. Even if a document doesn't say without prejudice, the court can still treat it as confidential based on its content and purpose. It also reminds the parties to be careful when negotiating settlements. Any statements made during these talks may not be allowed as evidence in court. To avoid this, parties should be mindful of their wording. That's all for me. Thank you.